Hello everyone and welcome back. In this session we're going to explore further minority shareholder protection under UK company laws, specifically statutory remedies such as the unfair prejudice petition and the winding up petition in terms of the Insolvency Act. Previously, we looked at the common law background, including the rule in Foss versus Harbottle and the derivative action. Please do have a look at the video that I've recorded specifically on the derivative action, which I'll link up here and in the description to this video. Now we turn to the most effective modern statutory mechanism that allows shareholders to challenge unfair behavior inside a company. We'll focus on two key remedies: the unfair prejudice petition under Section 994 of the Companies Act 2006, and the just and equitable winding up under Section 122 of the Insolvency Act 1986. These are powerful tools that allow courts to intervene when the company's internal management becomes unjust or oppressive. Let's begin. The Companies Act 2006 introduced a range of statutory remedies for shareholders. We've already discussed the derivative action, which allows a shareholder to bring a claim on behalf of the company when directors have breached their duties. In this session, we move beyond that and look at other statutory options: the unfair prejudice petition and the just and equitable winding up. These remedies exist because, in reality, internal conflicts in small or closely held companies often go beyond legal technicalities. They're about trust, fairness, and personal relationships. Before deciding which remedy to use, ask: has the shareholder's personal rights been infringed? If yes, they might bring a personal action, or they also have the option of an unfair prejudice petition. If not, if it is the company that has been harmed, then a derivative action is the indicated route. But remember that there's also there the option of an unfair prejudice petition. So you'll see that the unfair prejudice petition is available both to vindicate personal shareholders' rights as well as harms done to the company. So there's an overlap there. If trust and cooperation have completely broken down in the company, then the just and equitable winding up may be considered as a last resort. Under Section 994, any member may apply to the court if the company's affairs are being conducted in a manner unfairly prejudicial to their interests. It's not limited to minority shareholders, though they are the usual applicants. Importantly, the law focuses on members' interests rather than strict legal rights. Interests rather than rights. This allows the court to intervene even when no legal right was technically breached, as long as the behavior is unfair and causes harm. The Act doesn't define what counts as unfair prejudice, leaving it to the courts. In practice, it means behavior that harms shareholders' interests and departs from standards of fair dealing. Examples include exclusion from management, excessive director pay, misuse of company assets, or diluting minority shares. The key question is always: was the conduct unfair, and did it prejudice the shareholders' interests? To bring a petition, the claimant must be a member of the company, as defined in Section 112. There's no need for court permission, unlike derivative actions, which means that this petition is much more simple to pursue than a derivative action. However, weak or frivolous petitions can be struck out under the civil procedure rules. Once filed, the court has very wide discretion under Section 996 to grant a suitable remedy. So there's very broad scope, both in terms of what is considered unfairly prejudicial conduct, but also very broad scope as to the remedies that could be given by the court. The constituent elements of the claim is, number one, to prove that there was an unfairly prejudicial conduct of the company's affairs, that it affected the interests of the member, and the result was unfair prejudice. Let's look at a few cases. In Oak Investments versus Bortwood, this was between the QED Group Limited of companies and Oak Investments. Oak Investments was a company incorporated in the United States as a venture capital entity and which invested in QED Group Limited in the UK. The respondents here were Bortwood Brothers and QED Group Limited. Mr. Bortwood was the majority shareholder of QED, and he also conducted the affairs of QED in ways that were unfairly prejudicial to the interests of Oakwood as shareholders and financiers. For example, there was persistent failure to adhere to his role, he wasn't working within the agreed capital budget, and he was acting ultra vires. You'll remember ultra vires means outside of the authorized powers. There was also a very clear attempt by Mr. Bortwood and his brother to try and take over the sole ownership of QED. So Oakwood petitioned under Section 994. The court held that yes, this was a case for unfair prejudice conduct, but it also adopted a very purposive interpretation of Section 994. And the judge stressed that the provision was concerned with the practical reality which obtained on the ground in relation to the conduct of the company's affairs. And there it indicated that the courts are very hesitant to interfere in companies' affairs. In the case of regarding Corrowan, 2012, the company was formed to acquire the Savoy group of hotels, and the majority shareholders here were the Barclay brothers. Do go and Google the Barclay brothers, very well-known set of siblings in the UK. So the Barclay brothers had a plan to have complete control and ownership of the hotels. The minority shareholder, McKillen, petitioned on the grounds of Section 994, alleging breaches of directors' duties, and the court had to determine what was unfair prejudice in this case. It held that prejudice will certainly encompass damage to the financial position of a member, and the prejudice could be damage to the value of the shares, but it may also extend to other financial damage, which in the circumstances of the case is bound up with his petition as a member, position as a member. So, for example, removal from participation in the company in the form of remuneration will constitute prejudice in those cases where the members have rights recognized in equity, if not at law, to participate in that way. Similarly, damage to the financial position of a member in relation to a debt due to him from the company can, in the appropriate circumstances, amount to prejudice. The prejudice must be to the petitioner in his capacity as a member, but this is not to be strictly confined to damage to the value of his shareholding. So, moreover, prejudice need not be financial in character. A disregard of the rights of a member as such, without any financial consequences, may indeed amount to prejudice falling within this section. So let's look at a few examples of unfairly prejudicial conduct. Exclusion from management, serious mismanagement of the company, breach of directors' fiduciary duties, excessive remuneration, failure to pay dividends, diverting the company's property to particular shareholders, and diluting shareholding. All of these are examples of things that might be seen as unfairly prejudicial conduct. In Phoenix Office Supplies, the court held that it doesn't mean that a shareholder can, however, use the unfair prejudice petition to try and exit at will from a company. So it doesn't boil down to the equivalent of a no-fault divorce in corporate law. In this case, the claimant wanted to get out of the company. So he resigned as a director, but he wanted his shares bought out. So he applied to the court and he alleged that he was excluded from management by the others. The court, however, held that removing yourself doesn't mean that the others have committed an unfair prejudicially conduct. In Elgin Data, the question was whether mismanagement of the company will count as unfairly prejudicial conduct on the value of their shareholding. And the court said that, well, this will depend on the seriousness of the mismanagement. And the judge observed that the risk of poor management is incidental to shareholdership. So no risk, no reward, and sometimes your risk will not pay off. So the courts are not very keen on second-guessing business decisions. It has to be really serious mismanagement before they will see any business dealings as unfairly prejudicial conduct. And finally, regarding London School of Electronics, it was held to be unfairly prejudicial for the defendant to divert students away from the company to a new venture which he himself was setting up. What are the remedies? Well, it's very wide. The court can basically give any remedy that it feels fit. So This includes, for example, an order to regulate future company conduct, an order to prevent specific acts, or to authorize certain proceedings, even to amend the company's articles. But most commonly, the court orders a buyout of the petitioner's shares at a fair value. And this allows the parties to separate without destroying the business. That then brings us to the next weapon in the toolbox of the shareholder, and that is to petition for a just and equitable winding up. Under Section 122 of the Insolvency Act 1986, the court may wind up a company if it is just and equitable to do so. Now, this is a last resort when the company's internal structure has broken down beyond repair. And usually this is something which happens in the smaller companies. The court will usually also refuse if there's any other effective remedy available, any alternative, such as an unfair prejudice petition. The typical grounds for a just and equitable winding up petition include breakdown of mutual trust in small partnership-style companies, shareholder deadlock, mismanagement, or failure of the company's original purpose. So this remedy is particularly suited to companies that began as personal ventures, but where relationships have completely collapsed. Let's look at two cases arising from this. Firstly, let's start with Ebrahimi. So Ebrahimi versus Westbourne Galleries Ltd was a 1973 case where a company had been formed by two men effectively as partners. So a company, but only two men involved there, and they were acting very, very closely with each other. So this concept of a quasi-partnership meant that companies, yes, they are distinct legal persons, and we remember that partnerships do not have separate legal personality. The reference to a quasi-partnership is to situations where a company is formed, but in circumstances in which a very small number of people, usually two, have created the company as a vehicle for the small business that they began together commercially as a joint undertaking. In Ebrahimi, the founders of the business shared the management of the business and all the profits. They were the original subscribers to the Memorandum of Association, the first directors, etc. It was these factors that led the court to hold that it was a quasi-partnership. In time, a third man was made director of the company and granted shares. This man was the son to one of the original founders of the company. Consequently, the father and son together had enough votes to constitute a majority shareholding in the company. And over time, the father and son fell out with the other director, and they effectively ousted him as a director of the company. As a result, that minority shareholder and director then decided to present a petition to the court seeking the winding up of the company. The court granted the petition, and Lord Wilberforce said, "The just and equitable provision does not, as the respondents suggest, entitle one party to disregard the obligation he assumed by entering a company, nor the court to dispense him from it. It does, as equity always does, enable the court to subject the exercise of legal rights to equitable considerations. Considerations, that is, of a personal character arising between one individual and another, which may make it unjust or inequitable to insist on legal rights or to exercise them in a particular way." Now, Clemens versus Clemens Brothers was a case where the claimant owned 45% and her aunt 55% of the shares in a company, with the Articles of Association giving the claimant preemption rights. So she expected to eventually gain total control of the company on the aunt's departure. The board of directors was made up of the aunt plus other non-shareholding directors. And they then decided to issue new shares, which would go to the other directors who didn't by that time already have shares, and the employees' trust. Now, this decision to issue new shares was bona fide, made in good faith, but the court held that the effect was to reduce the claimant's shareholding from 45% to below 25%. And the court set the resolution aside, and they said that this could be done on equitable grounds. So the significance of this case is that it signaled that the Ebrahimi principles could be extended beyond winding up to other orders, such as setting aside a resolution which happened here. Under Section 124, any contributory, meaning any present or past member, can raise the petition. However, because winding up is such a drastic step, courts look for alternative remedies first. So if an unfair prejudice claim could fix the situation, that route is preferred. What about other protections? Apart from the derivative action, unfair prejudice petition, or just an equitable winding up? Well, there are other protections, and they include the right to alter the company's constitution, to call meetings, or to demand a poll, a vote. And when we're dealing with really serious cases of misconduct, you can also request a government investigation. Obviously, this would be for big companies and very serious misconduct. I'm giving you a few examples here of such investigations that were conducted by the Department of Trade and Industry. For example, the case or the investigation into Pergamon Press in 1971. In that case, they just made it clear that such an investigation, it's not like a court case, so we don't follow the court procedure and all the rules of evidence in a court, but we follow the rules of natural justice, which would mean that both parties are told what are the allegations and given an opportunity to respond, for example. Just a little bit more about the case of Maxwell. So this case, Maxwell versus DTI, arose from an investigation that was done in terms of the Companies Act by the Department of Trade and of Industry into the affairs of Robert Maxwell. There he is, a picture of Robert Maxwell, and he happens to be the father of Ghislaine Maxwell, who presently at the time when I'm making this video is still in jail in the United States, as she was the associate of the pedophile Jeffrey Epstein. So getting back to Robert Maxwell, however, he took the Department of Trade and Industry to court because he alleged that the investigation into his affairs didn't follow the rules of natural justice. And they clarified in the case how far do the parties need to go in terms of ensuring that the other party has got the right to reply, etc. One final another interesting investigation by the DTI was the MG Rover report. I will paste a link to the Guardian article on this matter in the description below. And in this case, a number of directors named the Phoenix Four devised a scheme to pay themselves in excess of £45 million from a deal that cost them only around £10. So do read the article for yourself. It's very interesting. To sum up then, minority shareholders have got a variety of options. If a personal action is not apt, there's the possibility of a derivative action on behalf of the company, but it's procedurally very onerous because it in actual fact means going to court twice. Then there is the very powerful tool of the unfair prejudice conduct petition, and finally a petition under the Insolvency Act to wind up the company. Now together they balance majority control with justice and accountability. Company law ultimately aims to ensure fairness in how companies are run, even when personal relationships within them fail. And that then concludes our session on further statutory protection for minority shareholders. If you found this video useful, please do remember to like and subscribe, and also check out my other videos on company law. I aim to upload quite a few more. Thank you for watching, and I'll see you in the next one.